2013, and he became a partner in 2019. So it didn't take him very long, but he did. He spent 7 years working for Arvest Bank as an auditor and commercial lender. While working in Arvest, he obtained his 7 Series and Series 66 security license, allowing him to work with individuals and their advisors to formulate personal wealth and estate strategies. He hasn't made me a millionaire yet, but he's working. So Mr. Price focuses on commercial transactions, estate planning, trust administration, assisting clients in all aspects of real estate and assets-based transactions. He represents financial institutions, borrowers relating to commercial loans and credit facilities. He is a native of Northern California, don't hold that against him. And he's lived in Northwest Arkansas since 1988. He and his wife Jenny are married since 2010, and they have the wonderful and cutest little boy named Joseph. He's a character. BR likes to camp and fish, and he also likes to play golf. I've known BR for quite some time, so please welcome BR Price. And we're going to talk
going on 30 years or so. So yeah, Luann asked me if I would come talk about everybody's favorite topic, unlawful detainers and evictions. Yeah, I kind of put together this handout here. Kind of just the step-by-step process of it. Obviously, the goal is to not have to do this. Everybody pays their rent and maintains the property, and everybody's happy, but that doesn't always happen. So, unlawful detainer is basically a statutory scheme in Arkansas that is essentially an eviction process. So if you've got a tenant, obviously if they're in breach of the lease, whether that's behind on the rent, past a cure period, they're damaging the property, the cops have been getting called every week and it's a nuisance, they got 20 cats in the house and they're not supposed to have pets, anything like that. So if they're in breach of the lease, then probably the best and most effective way to get them out is through an unlawful detainer process if they won't leave on their own. So once you basically said, okay, they're in breach of the lease, we need to get them out. We've dealt with them long enough, and so before we can file an unlawful detainer complaint, you have to file what's called a notice of unlawful detainer. And so what you do is it's a document. I think Luann had a few samples that
let me try
will probably work.
Let me see if I can work this and I don't lose everything. Otherwise,
so that document essentially just doesn't have to be physically served like a process server, but it has to be posted on the property, usually just on the door of the property, and document that it was posted when it was posted. And so basically what that says is, hey, you're in breach of the lease, you have 3 days to get out. After that 3-day period has expired, we're free to file the unlawful detainer complaint with the court. So that's something that if you're an individual and own a property in your personal name, you can try and do it by yourself. There's a few steps to it. If you're an entity, because you own your property in an LLC, entities can't represent themselves in court, so then you have to have an attorney do it. I would probably recommend having an attorney do it either way, but if you own it individually and you want to give it a shot, go for it. So we file that unlawful detainer complaint, and basically there's a complaint that lays out, that they're in breach of the lease. There's a copy of the lease. Here's how they're in breach. Here's how much rent they owe, etc. That gets filed with the court, along with, generally, we want to get an affidavit signed by the landlord, the property owner, the property manager, that basically spells out how much rent is due under the lease, that they're in breach of the lease. Mainly that's there for if down the road we want to try and get damages, we don't have to have some kind of hearing and bring somebody in to be a witness and explain all that stuff. We've already got it filed in the case. So we'll file an unlawful detainer complaint, that affidavit. There's a notice of intent to issue a writ of possession. And so that is basically just a document that says, hey, if you don't follow the rules, we're going to get a writ of possession possession issued against you. And so we file all that stuff, get a summons from the court, and then we have to serve the tenant with that. And so I saw you had Cody as one of the affiliates. Cody's one of the process servers I use a lot. You can serve it on them personally. Again, you can serve it on them personally if you want to. Some people are perfectly comfortable with that, some don't want to. You can get a process server to do it, or another way to serve is by certified mail requiring a signature. Generally the slowest way to do that. We're usually in a hurry, so I generally will get the process server. You know, they usually charge $50, $75 to go serve it. We get it served quickly. So once they are served with all that paperwork that we filed, they have 5 days, not including holidays and weekends, to file a response with the court, essentially saying why they're not in breach, etc. If they don't do that within that 5-day period, we can proceed to get writ of possession. Depending on the judge, sometimes they'll want a proposed order sent to them, but most of the time you can just get the clerk. Once you send an email, call them and say, hey, we're past the 5 days. So the court clerk signs the writ of possession. If they do file a response in that 5 days, if they probably have done this before and know how to play the game, so to speak, they know that even something as minimal as a handwritten note that sometimes is illegible and incomprehensible is enough to delay it to where we have to have a hearing. So if they file a response in that 5-day window, generally we're going to have a hearing in the court that basically gets the judge to order the writ of possession. If they're contesting an unlawful detainer, if it's because there's rent that's past due, in order to continue forward and not have the writ of possession issued, they are required by law to deposit all the rent that's due with the court registry while they're challenging that. So that's usually where we automatically win in that scenario, is say, okay, we want to issue a writ of possession if you deposit all the rent. They don't do that, and we get the writ of possession. Once you have the writ of possession, that's what you have to do, is you have to get the sheriff's department essentially, or to serve it on the tenant or post notice. So what they do is they try for a day. If they aren't able to do it within a day, they're allowed to post it on the wall. But basically what the writ of possession says is you got 24 hours to be out. Once that 24 hours is passed, you'll have to coordinate with the sheriff usually to get them out there, to meet you out there, to get them out of the property, change the locks, keep the peace, remove the property. So that's another thing. If they've got all their stuff still there, it's kind of a muddy area of what you are and aren't allowed to do with it. The way the statutes read is you have a lien on that property that's in there. So usually what I say is 30 days is a safe time period. It's a pain in the, but I have had times where landlords have just gotten rid of it, thrown it all away, and the tenants come back and file. It's probably worth hanging on to it and then just provide them a way to say, hey, you've got this amount of time to come get your stuff, or we're going to sell it or throw it away or whatever. So once you've got them out, essentially, sheriff's done that, you've changed the locks, you've still got the case that's open, because it's like any other lawsuit where if someone gets served with a lawsuit, they've got 30 days from the date that they are served to file a formal answer in the case. So they may have filed that little handwritten, hey, that doesn't end it. So if they're out, then the decision is, okay, do we want to move forward and take this thing to the finish line, get a judgment against them for all the rent that's owed, damages to the property, all that sort of thing? Or do we, decide, okay, we just want to get them out, get a new tenant in there and move on? The consideration there is basically, okay, are we gonna ever be able to collect this money? Because you're gonna spend extra money to take it further. The question is, okay, are we throwing good money after bad at that point? And some people wanna take it and get a judgment, and, you know, somewhere down the line, if they're trying to do a real estate transaction or anything and it pops up, they're not gonna be able to do it without paying that off. And so every once in a while, you'll get a surprise of a call from a title company or something and say, hey, what's your current lien amount, and get paid. A lot of times you won't. So it's a consideration too. You can always report them to collections, that sort of stuff, or it at least shows up on their credit report, that sort of thing, if you don't wanna take it all the way to getting damages and a judgment. Because then once you have it, unfortunately, that's what I always tell folks, like, okay, you got a judgment. Unfortunately, the judge just doesn't tell them to break out their checkbook while you're standing there in court and write you a check. You've gotta go try and collect it, whether that's garnishing wages or bank accounts or whatever, and that, of course, costs money as well. So yeah, the timeline on that process, if you file it and they don't file any kind of response in court, if we can get them served in a pretty timely manner, you can have them out in 2-3 weeks, more than likely, if they don't leave on their own, once they kind of see the writing on the wall. If they do file that response, you've gotta get on the judge's calendar whenever they have time to have a hearing, and it can take a while, you know, months sometimes, depending on the court's docket. So yeah, it can get drawn out if that's the case, just to get the rid of possession. That's usually the most important thing to the landlord, is we want them out, and then we can figure out the other stuff after that, and whether it's worth taking it further. But yeah, so it just depends. Like I say, some people know how to play the game, and they know the little things they can do to drag it out as long as possible. And so then, yeah, it takes a couple months. Some folks don't, and it's a pretty quick process. It's a decent amount of paperwork up front that gets filed, and then it's kind of just waiting games, just like a lot of stuff. But yeah, I mean, the best thing is obviously do your diligence on your tenants, try and get the best tenants, credit checks, all that stuff. But you know, things happen. People lose jobs. People, whatever, divorces, like we were talking about, that make it where they can't pay their rent. Usually, you can probably tell what situation they're in versus others. But yeah, once you get to where filing an unlawful detainer, it's just kind of a step-by-step process, depending on what the tenant does. So, cost-wise, everybody wants to know how much is this gonna cost me? It kind of depends on which step you end up getting to. If you're lucky enough where it's you post the notice and they leave, which rarely happens, not much. If we have to actually file the complaint and then they don't file a response, I'm gonna get rid of possession. Probably $700-800 to do all that, probably, plus the filing fees. If they know how to play the game, we have to have hearings and all that stuff. Who knows at that point? But it can be, a couple thousand, $2,000-3,000 to get it done. So, yeah, but a lot of times it never makes it past that writ of possession phase. So usually they don't file a response, and they're out, and we get the sheriff and they get them out, and it's over with. And then it's just a matter of, do we want to take it to the point where we get a judgment or not? The times where I see where most people file responses more often, it's not when they haven't paid rent, but it's when they're breaching the lease in some other way, and they want to argue about it, whether, well, I'm not in breach of the lease, or you said I could have 6 dogs, or I've got 3 other people living there with me that aren't on the lease, that kind of stuff. And so usually that's where they'll try to challenge it more than, hey, you haven't paid rent for 2 months. So that's pretty cut and dry. So usually those are, we get the writ of possession after that five-day window and get the sheriff out there and get them out and change the locks and, repaint and do all the stuff you have to do when a tenant moves out. So yeah, I don't know if anybody has any questions, but yeah.
In case of you're not wanting to renew the tenant's lease.
Yeah.
And you have given them enough notice, and they are still there.
So if they're a holdover tenant, essentially if you've reached the end of the lease and you haven't signed a new lease, they become a month-to-month tenant. So if you want them out, you essentially have to give them, and they pay rent, you essentially have to give them 30.
Send them a letter of renewal.
Yeah, you have to give them 30 days notice essentially at that point. But if they haven't paid if they transferred to a month-to-month on January 1 and they don't pay January 1st rent, you don't have to give them 30 days notice at that point.
We had that happen, and then finally, they just decided to move out, because, we told them there are people going in and out of the house, and we told them we're gonna have the police survey that house, and then they decided to move out. So I don't know because they would not wanna move out, they like the house,
I'm sure they
but
were
at
just
the
making
same
quotes or
time,
something.
yeah.
I was just gonna say, on that note, remember, if you're a member of the chapter in the state, we have that statewide lease agreement. And there's a place where you fill in the blank that we'll talk about, even when they're a lease holdover, you can put in a daily amount being charged.
Yeah.
We're not even really interested with their payment anymore, we just want it to go.
Well, I understand, but that does
Yeah, I mean, at some
help.
point, late fees and stuff are great, but if they're not paying it, they're
Yeah.
just not it.
But it does help in the
Sure.
whole scheme of things, that we do have that covered in there.
That's,
And having those things spelled out in the lease is always helpful, so you're not relying on statutes or whatever, it's spelled out in there. Yes.
So thank you. I think the state lease has, language about belongings that are left behind, that they are considered abandoned.
Mhm.
And but is it different because of this process,
They-
or can you
Technically
comment on
they
that?
are, there's,
And also, how do you handle it, I guess even more importantly, if we do need to do this 30 days, like, how do you navigate them coming back and getting their stuff, like, you have to meet them at a, make appointment?
Oh,
or,
yeah,
like,
no, you set an appointment, you make an appointment.
yeah, it's a bit of a pain, and so there's competing statutes on that, which is why it's kind of a gray area, because they both kind of say different things. There's one side that says, it's totally abandoned, the second they move out, you can do whatever you want to with it, and there's another one that says you have to give them a reasonable time to reclaim their property and all that stuff.
You
So-
can move it to a storage
Yeah, and
shed.
that's what I said, you can store it,
Mm-hmm,
but I would give some time, just to make it black and white.
Even
that
if
you
your
have-
lease says that.
Even if the lease says, there's some things that you can't contract over. So,
The lease can't contradict the law.
yeah, I mean, some things you can have the lease say that it's, contractually the statute will say, unless otherwise agreed or something to that effect. But there are certain things that matter what the contract says, that your lease can say you could, turn off the utilities and all that stuff, but you can't do that. Yeah,
And that statute doesn't give a number, I'm guessing, it
No.
says reasonable, like.
yeah, so
everything
that's why I say
reasonable.
30 days I think is reasonable, and I've never had a situation where it was determined that it wasn't. That's probably on the long side though.
One thing we do a lot is we'll try to get the tenant to say that they are totally done, they're not coming back.
Yeah.
Like, Cynthia will text message them, are you done at the house? Yes, or have you got everything out you want? And if they respond, then we've got a written.
I would say at that
response.
point, yeah, I mean, just document it.
Then
So-
we get rid of it, and, we actually had an interesting case one time, but the guy that worked for me in an apartment, they just trashed this apartment, stuff was all over the floor and everything else. Well, they got sued for getting rid of some stuff, and the lady, girl claimed she had meat stolen in there. and all
Oh, yeah, I got
kinds of
diamond
stuff.
rings that were there.
But she was getting Section 8 housing assistance. But the funny part is, in court, one of the maintenance guys testified, did you not think this stuff had value? And he said, well, I don't think, she didn't think it had value, and the judge said, what do you mean? And he
She
said,
left it there.
it was strewn all over the floor. If it has value, you wouldn't throw it all over the floor.
Yeah.
So, but one thing, we usually do try to either get them verbally, and preferably the two of us there where we can hear it,
Yeah.
or we get it in writing, text message or something.
You just
where
wanna
they say-
document that you've given them the
Yeah.
opportunity
And
to
that
get
they
it.
said that they're not coming back for anything.
Yeah.
And then if we do find something that appears to have some value that might have been left, we'll send a picture of it to them or something and say,
Yeah,
you know, and see if we get a response, if they wanna pick it up.
just try to cover your bases, and,
Yeah.
I mean, most of the time, they're not gonna be leaving anything that they're coming back for anyway, so it's never really an issue, but again, if they know how to play the game and wanna be a pain, that's one way they can do it, is to, you know, say I left my new coat there.
You were talking about the judgment part going on further, but we've had pretty good luck collecting on judgments for most of our properties. You know, if you're renting to people that have decent jobs and, you know.
Yeah, and that's the scenario, if you do your app and stuff, you know where they were writing their rent check from Harvest Bank, and you know they work for Tyson, well then, there's two very good avenues to
Yeah.
potentially collect on a judgment. But yeah, so that's a case by case, it's like, do we really think we have a chance here? But yeah, I mean, you can, and that's part of the front end, just making sure you get good tenant information and, you know, run credit and all that stuff.
I was gonna say, we had the credit company that a lot of us work with statewide come several months back. Two things very important on your applications, don't forget. Make sure you get their social security number, you get the name of their bank and their bank account number in your application. Because then the credit company, if they have those two things, then they can take their process a lot further.
Yeah, and sometimes doing, you know, background checks and that sort of thing isn't a terrible thing either. There's a few companies that do that, and they're pretty reasonable. They don't charge a lot to do it.
Yeah, we do those.
Sometimes that's pretty worthwhile. Is that ounce of preventions?
Back in, I think it was back in February or March, I told you all the totals of unlawful detainers that were filed in Benton County in 23 and 24. BR got me that information. BR, where are you at in 2025 as far as how many that you've kind of?
Countywide, was it like six
Oh, no.
or 700?
Oh yeah, we were almost up to
Each
900 and some
In
each
each county?
year.
There were a
So,
lot. I
yeah,
probably do personally 2 or 3 a month, probably.
and you're still keeping up at that pace in 2025?
Yeah, they come in waves, it seems like, but, so it may not be consistently, but then all of a sudden you'll have 6 of them come across your desk at once.
Yeah.
But, yeah, and a lot of them are people who, they didn't do the front end, you know, they're like, oh yeah, I talked to their old landlord and they said they did the same thing to them, and should have done that before you rented to them now, but.
This is the ironic thing, we've been doing this, I've been doing it 45 years, and we used to get a lot of phone calls from people checking references.
Yeah.
I know.
And we probably get, and we got 45 years of past tenants out there, and we maybe get one call a year unless it's like a Lindsay apartment
Yeah.
complex or something, so individuals have just quit checking those.
Yeah,
I
I mean,
will-
there's a reason your bigger companies do it, it's because
Mhm.
it's.
But that's a very
else.
good point, because as you well know, I travel around the state to the different chapters, and that has been coming up more and more and more in the last 6 months. Even, you know, on my local chapter is Faulkner County, because I'm in Conway. They just had their meeting a week ago, the same deal come up. You all are not checking references.
Yeah.
I've had 5 people, and I told them, I said, I've had 5 people in the last 6 months, and I know they went to somebody in this room, and you didn't call me, because you don't want them. And I don't know why the individual landlords have quit. Something that we're gonna talk about, and I'm gonna upload questions that you need to ask that landlord. I have
I
a
mean,
specific,
Generally, if landlord's been burned, they're gonna tell you.
Yeah.
Now, employment's a different animal, but
But if
Well-
you're wanting to get them out, they won't.
Yeah,
sign.
sometimes
That's
it's.
and the other,
That's an individual like a management company, a large company, they're gonna have policies for their managers, what they answer and what not.
yeah,
But most individuals that have 3 or 4 rental houses will get conversational, they'll tell you anything they wanna know.
well, but here's the other thing that's coming out on that too, is the other side of it. They're falsifying on the application, and they are not saying who that landlord is.
Yeah.
Because I called one a couple of weeks ago, and because of my experience, that lady was not the landlord.
It could be their relative.
Yes, yes. And the other thing, go back and check either ARA County Data or Data Scout. Find out who owns that property. Because you're gonna find out there, they have lied on the application.
What was
We
the other
caught
one
2
you
or
said?
3 like that, and we also look at their history, if there's a gap in there, we look for where
Yep.
we were living during that time
Yeah.
frame. And it's amazing, if they went and got a prepaid cell phone during that time, the credit bureau will have it on the credit report, that address they used, but, and so we'll call them up, say, tell us about 123 Pine Street. How'd you know about that, or, you know, you get this dead silence because they don't think you'll know about it.
yeah, I mean, in my mind, that kind of due diligence stuff on the front end is kind of just the price of doing business, and it's gonna pay for itself pretty quickly on the back end. So, yeah, it's, you know, you get folks like, well, I got the deposit money and ready to pay first month's rent. I need to get somebody in there, and you do it, and that's the only money you ever get. And then 3 months later, here we are. So,
I'm wondering if there is a better and best practice, because as an individual or a small landlord, whenever I call for reference and the other side is a partner in Lindsay, and they go, send me your questions.
yeah.
And
Yeah.
all you can do is to send a standard, have they paid? And it usually doesn't give you any information. I think that might be a deterrence, and it's like, okay, if I know that they're with Lindsay, it's
I know.
just a head scratch.
Well, no, it's true, and Lindsay is that way all over the state.
oh yeah, that's,
They will not give you, and they'll
Yeah.
say you have to send us this, you never get a response.
Right.
So hopefully, on your applications, you're asking for at least 2 landlords.
Right.
You've gotta go back to the other one, but then also do your research. You can call a licensed realtor, a lot of us have Forewarn, the app, we can check on that. So give us a
I
call.
have forewarned and I check. The thing is, there are so many possible or very strong connections. If you look at anybody, there's just so much.
Okay, well then
Yeah.
go to Court Connect, go a little bit deeper.
Okay.
Go on Facebook.
So after you look at that.
Yeah.
Yeah, Facebook's the other one,
Core
yeah.
Connect is very easy to search, and it's totally public,
Mhm.
and it's gonna pull up any,
It has a
Any-
huge warning though that says you're not supposed
You'll
to
even
use it
call it
if you're
traffic
for
tickets
whatever.
on there.
What did you just say? Who said, well, you're not?
Court Connect has all these warning boxes that come up and say, you know, you're not supposed to use this, or I forget the acronyms, but basically we promise to not use it for the purpose that we would be using it.
Your
But I
attorney
would
can say
recommend,
something.
Yeah.
I think it's good to ask, when I haven't gotten, sometimes I haven't gotten a hold of the reference, I go back to the applicant and say, I can't get a hold of this
Yeah.
person, can you?
I'm not doing
Can
this.
you
unless I
get,
talk to
yeah,
you.
I wanna talk to a real, especially, you know, someone that, has some questionable things, and, you know, if they tell me an explanation that makes sense, and they can give me a reference that, you know, where everything makes sense together, then it's like, okay, then
Well,
I'm
and
more willing to say.
they're not gonna, you know, if they're trying to pull one over on you, they're not gonna go through the extra effort that you're gonna make them go through. if that's the case generally, but, you know, I mean, there's stuff that slips through the cracks.
Another red flag is if you say, are you in a lease right now? Well, no. And they're, we're staying with a relative, or I've been living with, you know, that's another red flag.
Yeah,
They've gotten booted out and they're trying
you're
to.
never gonna get them all,
Yeah.
but,
What
yeah.
was the other site you said? You said Data Scout and so.
Data scout.
Data
It
Scout.
depends on what county.
Yeah,
Some-
AR County data has
Yeah, AR
both.
County data is Benton County, for
Benton
example.
County, Act Data Scout is Washington.
Washington,
And
and
a bunch,
several
yeah.
Madison counties on, I think, Act Data Scout.
And some counties pay them more and you get more info than
Mhm.
others. Washington County's pretty comprehensive for Ag Data Scout, Madison, not so much.
Question, I'm sorry, go ahead.
Oh, sorry. Okay, sometimes I pull up the previous address, and then just Google the picture. And if they're like really trashy houses
Sure.
on the Google.
Yeah, I mean,
I think that's.
you know, that's kinda like the social media, you know, it's amazing what you can find out,
Mhm.
you know, just doing a little bit of Googling.
Act Data Scout, for whatever reason, doesn't have photos of houses in Washington County, but they do in a lot of the other
Yeah.
counties, but I guess Washington County restricts that. Benton County, you've got pictures of the houses, like, you know.
Yeah, I mean,
previous
you can
houses.
do a quick
And you
address
can
search
also
on Google and
verify
get
through
street
that a lot
view.
of times if it's a legit address, if they're giving you a fake address.
Yeah, sometimes it pulls up and it's not even a residence, you know,
They'll give
or
you,
it's a
they'll give
vacant
you a
lot.
street name that's legit, but they'll give you a house number that goes to a vacant lot or is beyond what that street extends to.
So
One thing with social media, one of the red flags I always look at, if you go to social media and run their name, a lot of times it'll pop up where they're looking for a rental. A lot of times now you're seeing, looking for a private landlord, and that usually means they got problems and they
Yeah,
don't.
they don't
want to be
want,
screened by
they don't want
any-
Lindsay's process
Yeah,
or
they don't-
whatever.
They
that-
don't want
yeah.
somebody that's gonna process them, and that's usually a red flag, and then you can also see other things they've said, you know, I saw one day was previously asking if you'd rent to a felon, but then they didn't put it on our application.
I just want to know, but I'm not a felon.
Yeah. And we had one the other day that lied about it out of Memphis, Tennessee, and we had the, what's the name of the company we use?
Tenant data.
Tenant data re-verified it, and we always ask for a copy of their driver's license or government issued ID as part of their application. She claimed it wasn't her, but the name was the same, date of birth was the same. She was 5'10". Her driver's license said she was 5'11", so that helps you kind of narrow it down. And, then it turned out the address on the warrant, or the arrest, turned out to be match a place of business she previously worked. So, you know, we've verified it was her.
On that end.
Yeah, there's a couple companies that do pretty good stuff on, I haven't used it in a while, there's a place called Courthouse Concepts that's in Fayetteville that will do pretty thorough background checks, and they're pretty reasonable on the prices. It's probably worth doing.
What is
Yeah.
the name of the one you were?
Courthouse Concepts.
We also have a member of our Hot Springs chapter, Jeff Bailey is his name, and he's also, does that, and it's, you know, the tenant is charged or the applicant's charged for it, and he'll do it.
Yeah,
He's
it's
very,
part of the
very fast.
application fee. They usually charge, what, $25 or something?
Some of them, it's anywhere from $32 to $38,
Yeah, I was
depending on
gonna
who
say,
does it.
It's not a ton.
But the applicant's charged.
Yeah,
so
it's
you
called
don't
an
have to worry.
application, part of an application fee or whatever. Of course, depending on what city you're in, you're not allowed to do that, or
We are.
potentially.
Oh my gosh, I just blanked.
Still
I
want
had a
to
really important question, it seems so important.
I'm thinking about it quick before we let VR
Oh,
go.
well.
David, did you have
I
one?
had a question. We get a lot of cases where we don't do evictions, but we get the house back with some rent owed
Yeah,
or damages to the house.
you can still sue them for breach of lease if you want to.
Well, and we will sue for damages, and we go through small claims on those, which is, district court level,
Yeah,
which is easier to represent yourself in most cases. What do you think in Benton County, what's the likelihood, or are you familiar with that?
yeah, I mean, small claims, if you're under the,
5,000.
under the limit, and like I say, if you're not an entity, yeah, that's a good route to go.
Another question is, we got the $5,000 limit, and we're testing one right now in Washington, Crawford County. But we've sued the person for $4,400 worth of rent and late fees and things like that are contract-related financial. But they also left the house with a lot of trash and damage. So we're gonna try filing a separate small claims for damages to the property.
Yeah.
And I don't know if there's a legality on that.
We'll see if they'll, I mean, worth a shot. Worst they can say is they're
Let us
gonna
know.
consolidate
That way
it,
we'd
or
probably
kick it up to circuit
We'd
court.
probably get another $3,500 out of the second case.
Yeah.
So we, saves us going to circuit court.
Remember?
Yeah, I do.
Okay, yeah.
It's about, and so one of the reasons I would maybe want to go that next step is to prevent, is so that it's on their record.
Yeah.
So how far do you have to, so that other landlords, sorry, I'm not being very articulate, but I wanted their credit or whatever, I want it to show up,
You
when
can send
people
them
are
to
doing.
collection, you can send them to collections and
Turn
that
it
will
over.
show up on their credit
Turn
report.
it over to a collection agency.
So
You
that
don't
there will be a
necessarily
flag.
have to go get a judgment against them.
Right,
Okay,
right.
So, but having the judgments, the way they work is like they attach to property you own in the county, that sort of thing, for 10 years. You can always renew them too, but so if you have that, like I said, if they're down the road, they're trying to buy a house or whatever, and there's
Yeah.
a judgment out there, they're not gonna be able to close on that house until you get paid
Yeah.
off essentially, so.
More and more of us are starting to turn things over to collections
But
because we're
collections,
sick
yeah.
and tired of it. So I can't tell you that then the landlords in the state, they're really starting
And
to
all
turn stuff
all the
up
big, the Lindsays, that, they do it.
immediately.
That,
Yeah.
yeah.
Well, BR, we thank you. BR has his
And
card.
Melissa, Barnes, feel free if you have questions or whatever to call.
I